All right, Deputy McCaslin, we have who's ready, Deputy McCaslin?
Mr. Schmidt and Mr. Horton.
All right, Mr. Horton, if you'll step up, sir. All right, this is cause number CR 21-126-127 in 2021-90 State versus John David Horton. And Mr. Horton is set today on the issue of the application to administer psychoactive medication. Court finds that Mr. Horton has previously been found incompetent to stand trial and is awaiting hospitalization for purposes of restoration services. And the court also finds that Dr. Corman, who is present in our hearing today, has made an application to order the administration of psychoactive medication. Dr. Corman, if you will, sir, raise your right hand. I'm going to place you under oath for purposes of all of our hearings today. Sir, do you swear that the testimony you give in these cases today will be the truth, the whole truth, and nothing but the truth? So help you God. Oh, I'm sorry, Dr. Corman, you're on mute. You'll have to unmute. If you'll click that button there, Dr. Corman, on your computer.
Okay, good. Good.
There you go. Yes, you've got it now. All right. Dr. Corman, do you swear that the testimony you give to the court today in all these cases will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
All right. Thank you, sir. Dr. Corman, I just wanted to say I appreciate you being here today on short notice. I know that you've got other business and things that you've got to get done. We do appreciate you being here today. State, do you want to proceed on the application?
Yes, Your Honor.
Oh, I'm sorry, Mr. Schmidt, go ahead.
Judge, first of all, I've reviewed the application. I'll stipulate to the doctor's credentials as an expert. In addition to that, I have discussed the proceedings with Mr. Horton here today, and we've discussed the necessity for taking those psychoactive medications to help us get on track. As of right now, he has indicated his willingness to do that. So we are not currently in contest with the application, just for the sake of efficiency here today.
Okay, great. Thank you, Mr. Schmidt. So the court will take judicial notice of the application for order to administer psychoactive medication filed by Dr. Corman on April, it was filed a record April 22nd, 2022. I believe it was signed April 19th, 2022. Dr. Corman, I'm sorry, State, go ahead.
Your Honor, I would call Dr. Corman for just a brief summation of this application.
Yes, go ahead.
Dr. Corman, could you just briefly, for the record, summarize Mr. Horton's diagnoses?
Yes, he has a schizophrenic illness.
Okay, and you heard that Mr. Horton is currently agreeing to the psychotropic medication, but should his position change in the future, what would be the result if he were to deny taking those medications orally?
Further deterioration, worsening of psychosis, and further regression such that he would be more likely to be non-competent to stand trial.
Okay, so you do believe that there would be a degeneration of his condition without medication?
Yes, I do.
Okay. And the medications that are listed in the application, are all of those, in your medical opinion, medically necessary to treat Mr. Horton's condition fully?
Yes.
Okay. And this administration, should he refuse oral medication, would intravenous administration be the basically the least severe alternative to oral administration.
Intramuscular.
Intramuscular. Okay.
Yes, yes.
Your Honor, I'd pass the witness.
Mr. Schmidt, any questions for Dr. Foreman?
Yes, doctor. I guess, first of all, I'm new to these procedures. I'm glad we have them, but my question would be that if for some reason we got off track and Mr. Horton required intravenous, do we have both the medication available and the staff to administer that on a regular basis? And if so, how frequently would he need to get those medications?
Are you asking me?
Yes,
Well,
sir.
and so let me intervene here. So Mr. Schmidt, Dr. Foreman is with the Andrews Center and would not be administering the medications through his agency. He would simply prescribe the medication. They would have to be filled by the jail staff and then administered by the jail staff according to the doctor's orders.
Thank you, Judge. But as a doctor, what would be the frequency of dosage for an intravenous?
Well, again, it's not intravenous, it's intramuscular, just
Okay.
an important technical point.
Yes, sir.
It would depend. We would, it might initially have to be on a daily basis. If that was going to persist for more than a day or two or three, there are alternatives where we can administer a medicine that is administered monthly and lasts through the month. So we would try to minimize any event of his being, receiving intramuscular medication as much as we could.
Right. So doctor, I guess what I'm trying to understand is, so long as he's taking the oral medication, that would just be administered as you prescribe. In the event it's intramuscular, at that point, is it a varying regimen based on the type of medication?
Well, it does depend on the type of medicine. As long as he's taking the oral medicine, there'll be no need for intramuscular medicine. If he's refusing the oral medicine, then he would receive medicine by intramuscular injection. Those medicines would be daily, but if I'm saying that there are alternatives that we could move to if we see that he's not going to take oral medicines, which are monthly medicines. They're called depot medicines. So he would only have to get the injection once a month. Right,
doctor. I guess and I'm not trying to be argumentative, but I'm a layman, so I'm trying to understand. Yeah. If we had to do intramuscular, why would we not go straight to the monthly rather than the daily medication? Because
we would need to ascertain that he tolerates medicine given in a daily regimen without any side effects. Because if you give him on day one a new medicine in intramuscular depot form that will stay in his system for 4 weeks, I mean, if he doesn't tolerate that, you can't get it back out for 4 weeks. So we have to be sure that he tolerates it before we give him the monthly dose. I see. So what you're talking about is not the difference between one medication and another. You're talking about the dosage. It's the preparation. One preparation is designed just to last for no longer than a day. Another preparation is entirely different, and it deposits in the muscle and it leaches out medicine daily for a month. You can't get that back out of him once you give it. So you have to be sure with the medicine that wears off quickly, you have to make sure that he tolerates that medicine, that he's not, allergic to it or otherwise intolerant of it before you put in a dose that you can't get back. Right, doctor. I'm sorry. And I understand that part, but what I'm trying to figure out is, are there two different kinds of medications that would serve, one for the daily and a different kind of medication, like, versus whatever? Well, okay. It might be the same medicine. Say if we used Abilify, there's oral Abilify, there's a daily injectable Abilify, and then there's Abilify Maintena that lasts for 4 weeks. So it's all the same medicine, but different routes of administration and different forms of the medicine that we're talking about. And we just have to make sure he's either taken it orally or he's had a kind of medicine that will leave his system in a day before we give him the medicine that will last a month that we can't get back out of him if he doesn't tolerate it. It's just for his safety.
I understand. Thank you. That was good. That answered my question.
Yes, sir.
1 second, please, Victor.
I was just wondering if, I just wanted to say, let you know, Edward Chambers killed Allie Key, just so you know. Just want to let you know.
I'm sorry.
There you go. Now, a person found dead, your asses are fucking proven in prison. But no fun.
No further questions, Doctor. Thank you, Doctor.
All right, any further questions from the state?
Just briefly, Your Honor, Dr. Corman, how long on the daily injectables would it take to establish that he could tolerate it such that we could put him on the monthly?
Just a few days.
Okay, and would you be monitoring him during that? I understand you wouldn't be administering it, but would you be monitoring him in that time?
Well, I would be available we would be available to be called if there's a side effect or a problem.
Okay.
You know,
And then ultimately, would it be your decision to move from the daily to the monthly administration?
Yes.
Okay. Your Honor, no further questions.
Anything further, Mr. Schmidt?
Nothing further, Judge.
Okay. All right. Based on the evidence before the court having taken judicial notice of the application to administer psychoactive medications, the court finds that Mr. Horton has been found incompetent to stand trial. He is represented by counsel. He has been evaluated by Dr. Corman. The court finds him to be an expert in this matter. The court finds that Dr. Corman has diagnosed the patient with a mental health disorder. The court finds that the patient and defendant, in this case, Mr. Horton, lacks the capacity to make a decision regarding the administering of any mental health medications. The court finds that it would be the least restrictive alternative. The oral medication would be the least restrictive medical alternative to the administration of intramuscular psychoactive medication. The court finds that Dr. Corman has stated that he believes that Mr. Horton's prognosis is favorable and it would help him regain competency to stand trial. The court also finds that it could shorten the stay of Mr. Horton in the Benton County Jail and potentially any subsequent stay in a state-run hospital on the issue of competency. So with that, the court is going to grant the request, and the court is going to order that Mr. Horton undergo the administration of psychoactive medication. The court will find also that if Mr. Horton fails to voluntarily take those oral medication, and the court will on this day also order the administration of the classes of medication as indicated by Dr. Corman in his application intramuscularly. Anything further from the state or Dr. Corman?
Your Honor, state would rest.
Dr. Corman, anything the court needs to be aware of?
I would like to know what I'm charged with again. Would you tell me what I'm charged with?
I'll tell you.
Mr. Schmidt will do that for you. So what I'm going to do, Mr. Schmidt, I'm going to mute right now, and then you just unmute when you need to, okay? Dr. Corman, anything further that the court needs to be aware of regarding Mr. Horton?
I don't believe so.
Okay. All right. Mr. Schmidt, show of hand, anything further from Mr. Horton? Okay. All right. So the court has granted the application, and the court will sign the order for the administration of the psychoactive medication today. All right. Thank you, Mr. Schmidt. And I believe Mr. Horton, we'll set this matter upon request of either the state or the defense if need be. I don't believe. And Mr. Schmidt, if you want to unmute. Deputy McCaslin, if you want to unmute that device, Mr. Schmidt. Thank you, Mr. Schmidt.
Sure.
All right, so the court's not going to set this matter again unless there's a need to review his competency status.
That's good. Thanks, Judge.
All right, Deputy McLeish, who do we have next?
Well, Your Honor, we have Mr. Aguado's in the room, but his lawyer is not present.
Mr. Stevens is not there?
Correct. And Mr. Ashmore is in the room with maybe some information about Mr. Mannas.
Okay, Mr. Ashmore, if you'll step up, please. This is cause number CR 2182.
Yes, Judge. Good afternoon. Been visiting with the staff here and also walked back and did a visual inspection, attempt to communicate with Alex. It did not go well. My understanding from the staff here is that Alex, normally has good days and bad days, and most of the good days are, I think, what many of us would consider bad. But actually last week, he was relatively easy to get along with and non-confrontational, but that has not been the situation, as I understand it, this week or today. There's something antagonizing him, and I'm going to ask the court for safety and mostly for his as well. I think Alex needs to be where he is right now, and let's just carry on with this hearing.
All right, so
I'm sorry, Judge.
you're asking the court to waive his appearance today?
Yes, Judge.
All right, based on the statement of Mr. Ashmore as an officer of the court will waive the appearance of Mr. Alex Chad Mannas on this hearing, which is for purposes of the application for order to administer psychoactive medication. So Dr. Corman's already been placed under oath in another hearing. State, would you like to proceed?
Yes, Your Honor. State would offer State's Exhibit 1, which is Dr. Corman's application for order to administer psychoactive medication, forensic, which I believe the defense was given a copy of previously.
Yes, you have it.
Any objection, Mr. Ashmore?
No.
All right, court admits the application for order to administer psychoactive medication filed by Dr. Corman.
And we would briefly call Dr. Corman, Your Honor.
Go ahead.
Dr. Corman, you have evaluated Mr. Mannas, is that correct?
Yes, I have.
And briefly, what is his diagnosis?
Chronic schizophrenia.
Okay. And this is a long-term ailment, is that correct?
Yes.
Okay. And in your application, you have attached a list of likely medications that you believe would be of assistance to him in regaining some level of competency. Is that correct?
Yes.
And you say that you'd like to deliver them orally, but if refused, intramuscularly. Is that correct?
Yes.
And those are the least restrictive means for providing those medications to him. Is that correct?
Yes.
And with those medications, do you believe his prognosis for gaining competency to be favorable or disfavorable?
Favorable.
And as I believe we've discussed previously, but we're going to do it in this record, you'd like to provide them orally, but given what Mr. Manas's attorney is telling us, that's likely not possible, correct?
Well, he indicated to me that he's likely to refuse medicines. He actually was taking medicines orally earlier in this period of incarceration, but then began refusing. So I anticipate he'll refuse again, and may have to have the intramuscular backup.
Okay. And if we do intermuscularly, that is the least restrictive means of providing these medications if he refuses.
Yes.
And if he does not take these, as I believe you kind of indicated, is he likely to further degrade in his illness, or is he going to remain the same?
He's likely to further deteriorate in his illness.
Thank you, Your Honor. I would pass the witness.
Mr. Ashmore, any questions for Dr. Corman?
Just briefly, Judge. Dr. Corman, it's nice to meet you. I'm sorry we're meeting under these circumstances, sir.
Yes, sir.
When you met with Alex, was that here?
It was by telemed.
Okay. And in those meetings was, did you have any where the communication was positive, direct, where you felt like you could actually understand him and he you, or were they just all combative?
Initially, it was just one meeting. And during that meeting, initially we conversed and he expressed himself. But it wasn't long before he came to feel provoked by my asking him questions. And he began shouting and cursing. And that went on long enough that the jail nurse and I felt that there was no point in further questions at that time.
Okay, and on Exhibit A of your, well, actually the state's motion, but I'm assuming this is an Exhibit A that you prepared and you X'd certain boxes and highlighted certain possible prescription drugs or combinations that would be appropriate for Alex?
That's right.
This form? Okay. So we're not talking about giving him all of these. We're just talking about these are candidates.
Right.
That could be helpful.
Right. And we certainly wouldn't start out with one for the class. We would just really start out with one medicine, but those we might eventually need access to the others.
Okay.
Things go.
And first will be pill form and then a shot if the pills are refused?
Yes.
Okay. So let me just ask you, assuming that, like I believe, and because we're not opposed, that the state and we present this motion, the judge signs it, how fast would he be administered? How fast should I come back to check on him? A day, 7 days? How long before we might see some progress so I can report to the court?
I see. If he's taking the medicine daily, he might be somewhat improved within a week.
Okay.
It might take a little longer. It'll probably take quite a bit longer for him to get the maximum improvement he could have.
These medicines build over time and
yes,
they can help more the longer you're on them?
Yes.
Okay.
Psychosis is, especially a psychosis that's been present for months, takes time to recede, even in the best case.
Okay. Thank you.
Progress in a week.
I'm sorry, I didn't mean to interrupt you, doctor. It's the cadence of Zoom. Forgive me.
Of course. No, I just said we might see progress in a week or perhaps 2.
Okay. Thank you so much. Thank you, Judge.
State, any additional questions for Dr. Corman?
No, Your Honor, we would ask that the order be signed.
Anything further, Mr. Ashmore?
No, Judge, we're in agreement.
Okay. All right. The court then, having considered the testimony of Dr. Corman in the application to administer psychoactive medication, court finds that Mr. Alex Chad Mannas is charged with a criminal offense, that he has been evaluated and found incompetent to stand trial, that he has a medical diagnosis of a mental health condition of schizophrenia. Court finds that the administration of the medication would be in his best interest. Court finds that he lacks the capacity to make a decision regarding the administration of said medication. Court finds that the administration of this psychoactive medication would be favorable to his mental health disorder, and the lack of providing this medication or failure to provide may cause continued deterioration in his mental health disorder. The court finds that the medication should be presented orally, and if refused, then intramuscularly. And the court would find that the intramuscular administration of medication would be the least restrictive means of providing this medication. So the court hereby grants the application and will sign the order authorizing the administration of the classes of medication attached to the application filed by Dr. All right, thank you, Mr. Ashmore.
Thank you, Judge.
Mr. Stevens, are you ready with Mr. Aguado?
Yes, sir, I am.
Your client come with you. This is cause number CR 21317. State of Texas versus Joseph Dan Aguado. This is a hearing on the application to administer psychoactive medication. Dr. Corman is here. and he has already been placed under oath. Mr. Stevens, State, would you like to proceed?
Yes, Your Honor. State would move to admit State's Exhibit 1, the application for order to administer psychoactive medication forensic, which I do believe has been provided to defense counsel previously.
Objection.
All right. Did you say that was State's Exhibit 1?
Yes, Judge.
All right. There being no objection, the court admits the application as State's Exhibit 1.
We would briefly call Dr. Corman.
Fred?
Dr. Corman, have you evaluated Mr. Joseph Aguado?
Yes, I have.
And can you briefly describe his condition or diagnoses?
He has a schizophrenia spectrum illness, as well as depression, and by history, he was noted to have attention deficit disorder as well in the past.
And attached to State's Exhibit 1, there's a list of classes of medications that you believe would be beneficial into restoring Mr. Aguado to some level of competency. Is that correct?
Yes.
And those are the medications that would normally be given someone with the spectrum of mental health diagnoses that you have given. Is that correct?
Yes.
And in your application, you have suggested that he be given these medications orally, but if refused, intramuscularly. Is that correct?
Yes.
And orally would be the least restrictive, obviously, but if he refuses, would intramuscularly be the second least restrictive means of providing those medications to him?
Yes.
If he does take these, do you believe that there is a prognosis of favor? Is there a favorable prognosis for returning him to competency?
Yes.
If he is not given these medications, do you believe that his condition will remain the same, will further degrade?
I believe he will further regress and decline. Yes.
Okay. In your evaluation of him, was he responsive to you at all?
Yes, he was.
Okay. Judge, I would pass the witness.
All right, Mr. Stevens, do you have any questions for Dr. Foreman?
Just briefly, Your Honor. Doctor, when my client gets on the medications, any idea how long before he might have a positive response?
I hope we'd see progress within a week, and within the 2 or 3 weeks, more progress. If he's taking the medicines daily, I think there's reason to hope it would follow that time course.
That's all I have, Your Honor.
And Mr. Stevens, have you discussed this with your client at all?
No, Your Honor, I've not been able to.
Okay.
I mean, I've met with him a couple of different occasions, but I've not been able to communicate with him to any effective level at all.
Okay, thank you, Mr. Stevens. Anything further from the state, Mr. Woodwhite?
No, Your Honor, we would ask that the order be signed.
Okay. All right, court finds based on the testimony that Mr. Aguado has a mental health disorder. Court finds that he lacks the capacity to make a decision regarding the administration of medication to treat that disorder. Court finds that the administration of the medication would produce a favorable prognosis for Mr. Aguado, and that failure to provide this medication could result in the continued degradation or deterioration or decline of his mental health state. Court finds that the administration of the medication would be in his best interest, and the court grants the application. Orders that the medication be provided orally if consented by the defendant and patient. However, if the patient refuses, then the medication should be delivered involuntarily through the intramuscular administration. Court finds both of those to be the least restrictive alternative available for administration of those types of medications. So the court grants the application and will sign the order. All right.
Thank you.
Dr. Foreman, again, thank you for being here today. I really appreciate your assistance, and I will get those signed. I was given a question to ask you. Once I sign the order, will you be able to order the medications necessary for these 3 gentlemen?
Yes.
Okay, and so we just need to send that order back to you at the Andrew Center?
The court order?
Yes.
I suppose so.
Okay. All right, we'll get that done, and then hopefully by the end of the day, if not, then first thing tomorrow.
Okay, terrific.
All right, thank you, Dr. Corman. Thank you, Mr. Stevens.
Thank you, Judge.
Just 1 second, Steve.
Which one is?
Deputy McLeish, I'm ready when you are.
Schmidt, this is going to be you, sir.
Who's up first, Mr. Schmidt?
Nathan Sampson.
Mr. Sampson, CR 2135. This is a setting on Mr. Sampson's motion to revoke.
That's correct, Judge. We have received and intend to accept a plea offer from the state. We'd like to set this matter for a plea. Either the 12th, if we can do it, or that June 16th docket.
So remind me, Mr. Schmidt, so do we need 30 days or can you be available sooner than that?
Judge, I'll be here this Thursday, and then I'll be gone most of the rest of the month. So it depends on when the next availability is. I've been
Would you be out June 2nd?
I feel like I should be, but I can't confirm that. One second, Judge, I'll check mine.
Yes, sir.
On the 6th. Oh, we were supposed to have a test of prayer for the trial. I think I can do this, the second, yeah. Judge.
All right, court will set Mr. Sampson to enter his plea before the court on June 2nd at 1:30.
That's all I have, Judge.
Yes, thank you, Mr. Schmidt. I appreciate you being here at 1:30 too. Really do.
Thank you.
Mannas, you're up, sir.
Are you ready on, Mr. Adams?
Everybody. Always ready.
Which one you ready on?
Everybody, always ready.
Oh, everybody? All right, is everyone in the room?
Yes, sir.
Okay. Stephen Foster, CR 21-214. Mr. Foster set for a docket call.
Correct, Your Honor. Mr. Foster and I have conferred. Mr. Woodwike and I have talked about his case. I think we've got a plea offer of Mr. Woodwike to check his text messages to make sure that I've got the right number on that one. Then I think we can set him for a plea hearing.
I've received no text messages from you, Mr. Adams.
1, 2, 3, 4. I'm in a lead box.
I believe that is correct. Yes, I believe the offer is for TDC.
Then we need to set Mr. Foster for a plea hearing, Your Honor.
All right, are you available on, let's see. We can do it as early as May 24th or June 2nd.
Your Honor, I'll be here on the 24th, May 24th, so.
Okay,
that's a good time.
we'll set Mr. Foster then on May 24th at 1:30.
Yes, sir.
Yes, sir. Yes, sir.
Adam Joslin, CR 21-329.
Afternoon, Your Honor. Mr. Joslin's present, counsel. Your Honor, it was brought to my attention that there may be some CPS investigation records regarding the alleged victim and or at least her mother that, although not necessarily directly related to the allegations in this case, may be tangentially or materially enough related that they may be relevant. And so to that end, I have a global motion for discovery on file. If it doesn't adequately address that issue to the court's satisfaction, I can file one that is more narrowly tailored to that issue. I think we had this issue come up last year, and that old boy that we had the jury trial for in April of last year. I hate to put the court in this position, but that involved a lot of in-camera inspection of CPS records to see if anything was germane. Considering the gravity of what Mr. Joslin's charged with here, I think it'd be incumbent upon me to explore that.
You said that you do know that there are CPS records that do touch upon either this matter or the alleged victim or someone connected to this matter?
Now, I have not confirmed that directly through the DFPS, and I might need Ms. Curry's office to help me with that. She probably has a clearer path to contact with the DFPS office for Van Zandt County than I do. And it might be more economical time-wise to ask her to confirm or deny that for us.
And Judge, unfortunately, we have to go through the same process that defense attorneys have to go through. We have to send a subpoena to CPS, same as Mr. Adams does. And I don't know specifically what the scope of what he thinks is there. So perhaps if he could off YouTube provide me with more information, we could see about getting a subpoena for that. But I mean, I think he has equal access to the records as we do.
Let's do this. I'll reset this for an additional pretrial hearing. And then Mr. Adams, if you'll file your motion and if you'll lay out the scope, time, all this information that the state will need to make that inquiry, then state if you can't formally inquire and you have to issue a subpoena, then if you want to send that back to Mr. Adams for him to request a subpoena, that's fine as well. If you do have the ability to just inquire about the existence of records, that way that there doesn't have to be a preparation of a subpoena and then the production or non-production of records, that may be easier. But I think it'd be good to see it in a motion. That way it is narrowly tailored so that we know what the search parameters are.
Yes, sir. And Calvin Leroy Dunn, that's the case I was thinking of. That is I will just use that motion that I had on file there. In that case, I believe it was tailored narrowly to this specific issue of the same types of records in that case. So I'll get that on file this week.
And if there's going to be a request for any camera inspection, then I'm going to need to know allegations. I'm going to need to know times, names, relationships, because it's not always apparent in the DFPS records.
Certainly.
All right, so we'll reset this to give us time to work on it. I believe I set you earlier this morning on June 14th, Mr. Adams. We'll just reset this for an additional pretrial on June 14th.
Your Honor, I have a prior setting on June 14 in the afternoon in Harrison County over in Marshall.
You want to do June 16th?
I will be in San Antonio for a CLE seminar, a networking opportunity.
What about June 2nd?
Yes, Your Honor, that's fine.
All right, we'll set this for June 2nd then. Roger McCaslin. All right, I'm sorry, Mr. McCaslin is set for pretrial.
Yes, sure. We don't have any pretrial issues to take up at this time. It may be the case that I need to file something to get access to Mr. McCaslin's cell phone, which I believe is in his evidentiary possessions here in custody of Van Zandt County Sheriff's Office. Additionally, I don't know that this will be necessary, but I might need the assistance of an investigator to track down some individuals in the Dallas-Fort Worth area or the Dallas-Garland area. If I find that I need that assistance, I can always file an ex parte motion for an investigator funds, but I don't know that that's the case yet. So that's where we're at. I think we're going to be this case is going to end up in a trial unless something dramatic comes to light that significantly shifts the district attorney's office's opinion on this case.
All right, let's set this matter. Are you available on Tuesday, July 5th?
Your Honor, I will be in Cherokee County the afternoon of July 5.
July 7th?
I'll be here.
Okay. All right, we'll set this for docket call on July 7th. And if you file the ex parte motion or if there's any other discovery motion, you'll let me know.
Yes, sir. All right, I think that's all I have on the docket this afternoon. May I be excused?
Yes, thank you, Mr. Adams.
Excuse your Honor, thank you.
All right, this is cause number CR 21282, State versus Justin Lee Cannon. We were set for docket call today. Mr. White, I've granted your substitution of counsel and I've discharged Mr. Ashmore as appointed counsel. Any announcements?
We just got hired last week. I received the discovery on the 282 case. I believe that Mr. Cannon has another case that's pending, which is a family violence assault against another alleged victim. I have not received the discovery yet on that.
Is that in my court or is that in Judge Winter's court?
I believe it's in court.
There's an unfiled, appears to be unfiled continuous violence against the family that we will open for Mr. White, make sure he has access to.
Okay. I don't have jurisdiction over that case right now, so
Sure.
So I will reset this for an additional docket call to give Mr. White time to get up to speed with the state and discovery.
And for the record,
Go ahead.
for the record, I have explained to Mr. Cannon that I was going to need a little bit of time in order to properly evaluate this and get ready to go.
What did I set you for today earlier, Mr. White? What date?
I wasn't set for anything today, Judge.
Let's see. This morning, did you plea out your client?
No, sir. We just Mr. Woodwhite presented you with motion to dismiss.
Oh, that's right. That's right. Are you available on June 14th?
Let me check real quick, Your Honor. Would we be possibly able, I gotta be in Columbia County at 1:30 that day. Do we have a docket on the 16th?
We do.
Can I appear on that, Your Honor?
Okay, Court will set Mr. Cannon for docket call June 16th at 1:30.
Your Honor, that's all I have.
Thank you, Mr. White. Mr. Stevens, is this Mr. Tommy Jones?
Yes, sir, it is.
All right, this is cause number CR 22-106 and 107, set for arraignment.
Yes, Your Honor. May it please the court. I've gone over both of the indictments, CR 22-00107 and CR 22-00106 with my client. He advises in both indictments, his name spoke correctly. He understands the nature of the consequences contained in both indictments. Will waive reading of the indictments, enter pleas of not guilty.
All right, court will find that Mr. Jones has waived the formal reading of the indictment and the formal requirements of arraignment. Court will enter his plea of not guilty into the record, and the court will set this matter for pretrial hearing on June 14th. Is that enough time for you, Mr. Stevens? I know you've got two cases here. I see one's an ag robbery. I don't know how much discovery you've got to deal with. If you need more time, I'm willing to give that to you.
I think I'm probably okay, Judge. If I run into an issue, then I guess I'll address it at the next court setting.
All right, court will set Mr. Jones in for June 14th at 1:30.
Also, Judge, he is being held, he technically is on PR bonds for all of these cases out of Van Zandt. He's being held on 3 cases out of Louisiana, warrants with no bonds. So we're needing to do something to move toward extradition on those, or he's just sitting in the jail with nothing happening. So not sure where to go from here.
All right, Ms. Tabor has informed me that she's given Mr. Jones, I believe, some of the paperwork. Give it to me. I'm not sure what we're talking
about. And Judge, also, I did discuss with Mr. Jones the fact about the extradition and some papers that he presented.
Okay, as soon as I get my hands on that paperwork, we'll get it set up to discuss the extradition rights with Mr. Jones.
Yes, sir. Thank you, Judge.
Mr.
Yes.
Judge Draper, you can check out.
Thank you.
Yes.
All right, Deputy McCleach, I'm ready. Mr. Ashmore, who are you ready?
Yes, Judge, I've got one thing to request a call out of order. Jerry Elmore is in the day tank over here, and he's already signed for TDC 6 maybe a month ago. And I wonder if he's,
I show he pled 4/18.
okay, yeah, not quite a month, but
I noticed that he was on the docket. He's pled, and a penitentiary packet has been issued. I don't know where he is waiting for the bus to TDCJ, but He has pled previously. It's signed. It's been filed and everything. So I don't know why he's on the docket still.
Let me see where, I don't see him on my document.
Maybe it was on the original docket that the court coordinator sent out, and then it's been caught that he's already pled and been removed from yours. He's still on mine. Apparently he's on the one that Mr. Ashmore received. So if it's not on the court docket, that's fine. He has pled previously, or what my records show.
Yeah, I'm just making sure that, sorry about that. I'm making sure that there's nothing I haven't done to move him about his business.
Nothing
Not
I'm
that
aware
I'm
of. He's
state
as I
either.
said, he's not on the court's docket. So. All right, who else are you ready on, Mr. Ashmore? Anyone?
Mr. Yates, Your Honor.
Robert Yates, CR 29-7. All right, Mr. Yates, best that you can, raise your right hand. Mr. Yates, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you put your hand down. Your name is Robert Brandon Yates, is that correct?
Yes, Your Honor.
And Mr. Yates, are you a United States citizen?
Yes, Your Honor.
Do you read, write, and speak English?
Yes, Your Honor.
Have you ever been diagnosed with any type of mental condition?
My mental health, which I'm taking meds for now, PTSD.
What kind of diagnosis do you have?
It's just PTSD. I'm taking depression medication from military. I saw my dad letting his throat. He got shot in the throat, and I had bad dreams. They give me depression medication for it now. I'm fine.
Okay. Do you feel like you have rational understanding of what's going on here today?
Yes, Your Honor.
Okay. In this case, you're represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Yes, Your Honor.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read and signed today that you do not understand?
I understand everything, Your Honor.
All right. Mr. Ashmore, do you believe Mr. Yates to be competent?
Yes, Judge.
And you've explained to him all of his legal rights?
I have, Your Honor.
And you believe he understands them?
Yes, Judge. One, I want to thank the court for getting him back here so quickly after his heartfelt request to resolve this business and get out of the situation he was in Henderson. So thank you, Judge. We have had multiple discussions over not only the course of this case, but in particular recently to get him ready for this. We're in agreement. We understand the offer is 7 years. I've talked to him about knowing a voluntary waiver of his right to a jury trial, waiver of his right to an appeal, et cetera. And we are good with the agreement. We are asking the court to accept the plea.
All right, thank you, Mr. Ashmore. Mr. Yates, you are charged by indictment with a third-degree felony offense of assault of a family or household member with previous conviction. A third-degree felony in the state of Texas has a range of punishment of not less than 2 years or more than 10 years confinement in TDC and an optional fine not to exceed $10,000. You understand that full range of punishment?
Yes, Your Honor.
And as you heard Mr. Ashmore say, it looks like the plea agreement is you plead guilty to that offense. The state recommends to the court that you receive 7 years confinement in TDC with a $2,500 fine plus court costs plus reimbursement fees.
Yes, Your Honor. With my 7 months back time.
207 days, yes.
207 days credit.
Yes, Your Honor.
And state, I was looking at the reimbursement fees. It says 160.
I think 100 of that is the family violence fine. No, maybe not.
Just want to make sure that that's correct. I don't have the bill of cost, but anyway, that's your understanding of the plea agreement, what you want the court to approve today, Mr. Yates?
Yes, Your Honor.
All right, Mr. Yates, understanding the range of punishment, understanding the plea agreement, how do you plead to that charge?
Guilty, Your Honor.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
The court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. In regard to victim notification, the state is in compliance, and there is additionally an affidavit and non-prosecution on file in this cause.
Thank you, Ms. Humphrey. Anything further from the defense?
No, Your Honor.
All right, court's going to review the evidence. All right, the court's reviewed the evidence. I find enough evidence to convict Mr. Yates of this offense. The court will follow the plea agreement in this case. The court hereby convicts Robert Brandon Yates of assault of a family or household member with previous conviction. Court assesses his punishment in accordance with the plea agreement at 7 years confinement in the Texas Department of Criminal Justice. Court will order him to pay a $2,500 fine, $290 court cost, and $160 reimbursement fees. And the court will award Mr. Yates 207 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Yates, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with Deputy McCaslin to be fingerprinted. Good luck to you, sir.
Thank you, Your Honor.
You're welcome.
Right now. Oh.
Next.
Mr. Ashmore?
I need just a moment. Well, I can just.
Okay, that's fine. I can make an announcement on another case. This is cause number CR 21339, CR 21340, State versus Tad Michael Russell. Mr. Schmidt, Brian Schmidt was on the Zoom court. He was waiting to be called in, and it came to my attention that Mr. Russell was not set up to Zoom in from the Henderson County Jail where he is at. So Mr. Schmidt has made an announcement to the court through Ms. Tabraham that he's asking the court to reset for an additional docket call on June 16th at 1:30. Says he needs to go over the audio visual discovery with his client, and he has no pretrial issues other than going over that with his client. So the court's going to grant that. I'm going to set Mr. Tad Michael Russell for an additional docket call on June 16th at 1:30.
You ready?
Ready on Mr. Spriggs, Your Honor?
Yes, just one moment. You go ahead and bring Mr. Spriggs up.
Yes, sir. Okay. Your hands look like-
All right, this is cause number CR 21371, State versus Casey Lynn Spriggs, set for pretrial. And it's also my understanding, Mr. Spriggs, you filed another complaint against Mr. Ashmore. So let me hear from Mr. Ashmore first on the pretrial issues, and then we'll take up your additional complaint. Go ahead, Mr. Ashmore.
Judge, we've recently learned, one, we appreciate the accommodation of the sheriff's office and the state, letting us have the opportunity to go through the crime scene evidence, everything in the possession of the sheriff's office that's relevant to the homicide we've seen, and have the opportunity to see everything in its entirety that's over here. Much of it is not related to the homicide and has to do with the shallow grave. So those biomaterials were not disturbed. They were left in their evidence bags. That being said, Mr. Woodwike from the state prosecutor's office and I have been working since then to drill down on all the photographic and video evidence that the state has regarding Casey and this case, in particular the homicide. And I have a blank DVD which purports to be a recording of Mr. Spriggs' interview. My copy is blank. Mr. Woodwike has done some digging on that and has informed me that he believes the state only has a copy of a video with no audio. So I'm going to ask the court for leave to file another pretrial motion, because I think that the voluntariness of that interview and any Miranda warnings are questioned. They can't meet any predicate. And we're asking the court for leave to file an objection to that pretrial, because I think it needs to be ruled on. I don't think that's something that can wait till any attempt to introduce it. And last but not least, I know that there is a medical examiner's report, which is lengthy, that is at the prosecutor's office. I've been unable, due to my own conflicts and schedule, to look at that, because I need to look at it there as I understand it. And I'm going to try to do that today or this week, if not today. And I'm asking the court for some additional time to permit those things.
Mr. Woodwike, would you address the discovery issue?
Judge, there is a disc that purports to be the interview with I believe the sheriff's office and Mr. Spriggs. Our copy is blank as well. I have requested from the sheriff's office an additional copy. The copy that they have does have a video, but it does not appear to have audio on it. There is, in that video, there appears to be a body camera that the officer sets on the desk. I have requested that they perform an additional investigation into the existence of an additional video that may have the actual audio attached to it. But at this point, Mr. Ashmore is correct. We do not appear to have a video of the interview between law enforcement and Mr. Spriggs that we have a audio recording of. We just have a visual recording. I am not opposed to an additional pretrial for Mr. Ashmore and Mr. Spriggs, so we can continue that investigation, see if we can't find this other video that was not included in the original discovery. We only know about it because we happened to notice it on the video. I reached out to the sheriff's office to reach out both in their servers and whatever, I believe it's WatchGuard, to seek out any additional videos that may exist as well.
What about the medical examiner report?
That is here. It is present. Our investigator is available to help view that. We do not, as by policy, turn over medical examiner reports, but we will make that available at Mr. Ashmore's convenience.
Okay. All right. We'll reset this case for an additional pretrial. Are you available in the afternoon of June 14th, Mr. Ashmore?
Yes, Judge.
All right, court will set this for an additional pretrial on June 14th. All right, and Mr. Ashmore, have you been provided a copy of Mr. Spriggs' document called Defendant's Concerns with Court-Appointed Counsel file, signed on May 4th? Have you received that?
Yes, Ms. Abram provided that to me.
Okay. Mr. Ashmore, will you, do you want to address any of the allegations in the 6-point letter?
Respectfully, yes, Judge. I refute the allegations, obviously, that I'm not communicating with my client. We've taken advantage multiple times of both in-person interviews. Initially, when I got the case, video conferencing, which is available. I've updated him, showing him on the video conference every photograph of every piece of crime scene evidence that I thought was relevant to a further discussion with us. And I've kept him apprised of the entirety of all of the movements in this case, with the exception of the objection that I've lodged today, simply because the appropriate time to lodge that objection is at a pretrial hearing. And we learned of this information late last week. But Mr. Spriggs has been provided with updates, regular, frequent updates about his case. I know there is some frustration about the investigator and what to, sorry, Judge, I thought the phone was silenced, forgive me. Until recently, I haven't had a lot to use an investigator for. All the evidence is right here. I know there's some complaints about what's going to happen with his motor vehicle. His motor vehicle is in the possession of law enforcement. It's part of a crime scene. I've explained that that's not likely coming back anytime soon. It's been inventoried as part of a crime. So again, if there's any breakdown in communication, you know, of course I accept responsibility for it, because I have the mindset that it's all my responsibility. On the other hand, I'm not really sure how much more communicating and more pushing forward on this case that Mr. Spriggs expects. I know he likes to complain a lot about what's going on, and he's dissatisfied with a lot of things, including being here for over 200 days. We have discussed multiple times eligibility for bonds. We've discussed multiple times what defensive theories are. I believe Mr. Spriggs is as informed as any client could be about the nature of the allegations, and specifically the evidence against him, especially since we spent multiple calls going through the photographs I took regarding the video, or excuse me, the physical evidence that's here at the sheriff's office after Mr. Woodwike and I and Deputy McLeish completed our inspection here in the jail.
Mr. Ashmore, do you believe that you and Mr. Spriggs are at an impasse and can no longer communicate as an attorney and client must be able to do? I mean, Mr. Spriggs has accused you of creating a toxic relationship, and he's indicated that he's also alleging that you're committing a crime of official oppression, and that he has filed a grievance against you with the state bar. Considering those things, do you believe that you and Mr. Spriggs are still able to work within an attorney-client relationship?
It's not my first bar complaint. That I will tell you, that's probably the first thing I've heard from Mr. Spriggs, and the fact that he didn't have the guts to tell me that to my face definitely is a fracturing of the relationship. I'm not asking you to put me on the bench, but if you think that's going to speed up the attitude and possibly the resolution, I'll do whatever the court desires.
All right, Mr. Spriggs, let me hear from you.
Okay, I want to think down, because last time you caught me off guard. Mr. Ashmore denied me my rights by the Constitution and the Bill of Rights by the, by not allowing me the right to due process and the right to a speedy trial. Why not, he doesn't fill out the motions I asked him to, which, you know what I'm saying, the motion for speedy trial and all this. He had to file the motions, which I filed with the termination motion. I filed another PR bond, or bond reduction request, which I guess you didn't get again. You know what I'm saying, before, it's gotta go before the court. And that's 6 times I filed. He told me he was gonna file 3 times. And one has yet to come before the court on my behalf. You understand? And in appeals court, I don't have any objection. I don't object to it. I don't file the motion for it, which I've asked Mr. Ashmore to file, then I don't have no right to review. So come, you know what I'm saying, and if I have to appeal, you know what I'm saying, I mean, that there is, Mr. Ashmore knows, he knows that if I don't complain about it, or if I don't object, he don't object, then it's not up for review in the appellate court, which I don't know if he brought the defense to the EA. You know, got to be on record for me to be able to complain on appeal. Mr. Ashmore and I have come to a severe conflict of interest. He belittled me, calling me kid. Told the judge I gave confession, wrote it here on the paper, confession. I gave a statement on my behalf, my defense. And I think it's kind of hard to fight if your attorney's calling your statement a confession, Your Honor. You understand what I'm saying? He even wrote it here. He told you last time that we had this discussion. He told you 4 times that there wasn't no way in the galaxy that you're going to give me a PR bond. Well, look, I'm obligated to write. You understand what I'm saying? To be presented. Mr. Ashmore has refused me that right. Therefore, official oppression, because I'm a citizen. I did 15 years, on parole, not running anywhere. I was picked up from a mental hospital, which I voluntarily went into. They picked me up. You know what I'm saying? I'm not trying to run from this case, Your Honor, but it was self-defense, which I don't believe he brought to their attention. Defense of my property, you know what I'm saying? And I just don't understand why I can't get what I'm due. The rights, you understand what I'm saying?
I'm not sure I do understand what you're saying. You're telling me that you want him to file a motion for a personal bond.
Personal bond or bond reduction, anything.
And you want him to file a motion for a speedy trial.
Yeah. Yes, I've asked him to do both of them.
And what else?
No,
What else has he not done that you've asked him to do?
I don't believe that he's brought to the DA my defense. I know he has to do it in court, but I don't think he's bargaining with him. He told me when he got the evidence, which he showed me on his pictures, he showed me 4 different pictures of a shell, a bullet, a skull fragment, and a gun that my people give to the sheriff. You understand what I'm saying? I'm not running from any of this, which I don't understand why I'm being, it's 282, well, probably 85 days now that I've been here, which he hasn't allowed me. I've asked him. I filed 6 of them myself. You understand it? And in the appellate court, if no motions are filed, I don't have no right for review on that error. I don't, him calling me kid and all this, he told me, 40's off the table. He didn't even write me, I did. But he told me, they're going to get you 99. You know, word for it. I did it in self-defense, sir. For defense of my property. And I just believe Mr. Ashmore.
I'm going to advise you to stop talking about the
Yeah,
case,
okay,
right?
well,
You're educating the state of Texas about defensive theories that you need in trial
Maybe he thinks I'm,
to your detriment.
he's saying a confession, which I gave a statement.
Mr. Spriggs, you've referenced that you have property. You said that it was a defense to your property. What property are you talking about?
The car that is in impound.
Do you have any other property?
No, sir.
Do you own land or a home?
No, sir.
You have a bank account with any money in it?
No, sir.
Do you have family or anybody that could hire you an attorney?
No, sir. My family.
Can I address that just briefly? The family are material witnesses for the state of Texas in this case. And he has no relative within one generation living in Van Zandt County that can do any kind of surety that I'm aware of. I don't think that's close enough. And I don't think he has sufficient property, and we've talked about that, that can post any sort of surety that he'll return to court.
If I had an opportunity to pay for my own attorney, I would. Because I had property. My dad, when they locked my mom up, it upset him, and he sold everything. He gave it away so I couldn't have, you know what I'm saying, my own property he gave away. I mean, I got a job, worked for myself, you know, I got a tow truck. He left one tow truck, got rid of all the rest, like $250,000 worth of assets. You know what I'm saying? I lived down my parole. I'm just asking, you know what I'm saying?
You said you have a tow truck?
I had it at the house, yeah.
What else do you have at whose house? Your house?
Yeah, at my dad's house.
What do you own, Mr. Spriggs, that you could sell to hire yourself an attorney?
Just a tow truck,
How much is that worth?
maybe $5,000.
$5,000?
Yes, sir. It's an old 08.
Anything else?
No, sir. He got rid of everything. He gave everything away because my mom got locked up. And he, you know, I tried to file charges on him because the simple fact that he denied me my property. He robbed me of everything because my mom got locked up. I mean, I could sell it for $5,000 if I got to come up with that. I just need an opportunity to get me to pay for me an attorney. You know what I'm saying? I lived down to 15 years. I'm not running from nothing. It's not.
So you want me to just let you out on your word that you've been accused of murder, but you're asking me to let you out so that you can go to work and hire your own attorney. And in saying that, the way that you're trying to ensure me that is because you lived on parole out of prison for 15 years.
No, sir. I'm just saying I'm not running from the case. You know, understand?
I know, but you understand what you're saying? You're saying that you were a convict in prison and you've been on parole for 15 years. And you've been arrested for murder.
Yes, sir.
I mean, you hear it coming out of your mouth?
Yes, sir. I say it in prayer.
Yeah. Don't you think Mr. Ashmore's probably hearing that too?
Yes, sir. But I mean, they can at least try. I filled out the motions myself, and he's told me 3 times. You know, at least a reduction. Like I said, if nothing's complained about, nothing is up for review in the appeal court. If it comes to that, I want to fight the case, but I'm scared to fight with Mr. Ashmore for the simple fact that he's not. I don't feel that his best interest is in my life.
Mr. Ashmore, what do you want to do? I'll defer to you. I'll let you make the decision. If you believe that Mr. Spriggs is just going to continue to.
Well, if I could address this is the same whining and belly aching that we heard when Ms. Beasley was the attorney. And I actually spoke to Debbie Beasley, even though she's retired now, about this case, asking her to do another dive into it for Casey. And I know that this is eventually going to be somebody else's problem. So I don't back away from a fight. And if you want me in, I'm staying in, because I know this is just going to be some other attorney like Miss Beasley or somebody else who's going to just have to weather the storm, because Casey's storms he has highs and lows. We had a conversation about all the evidence. He was super happy about it, right? He had a positive outlook on it, right? We discussed all the ins and outs. And then today, I guess we're just at a low. So I'm not backing out. That being said, that's my position. I appreciate that, Judge. I just think it'll be some other attorney that you'll have to appoint, you'll be doing this in 30 days or 60 days, or if he doesn't feel like he's getting enough jail calls. That being the case, I wouldn't ask to be replaced. If we get to a fractured situation, or if the state bar or my ethics attorney, who I guess I need to call now, says I should step off, I'll ask the court for permission to revisit that. So I'll call Miss, I have a friend at Cobb Martinez. She's been advising me on these kinds of things for 15 or 20 years, and I'll call her today and see what she has to say about it.
All right, Mr. Spriggs, I'll take your request to remove Mr. Ashmore as your attorney. I'll take it under advisement. I'll let you know something on June 14th.
Thank you, sir.
Yep. Come on, Bubba. Oh, sorry, Judge, I'm coming.
Is this Mr. Wilson?
Yes, Judge, I apologize. I was making some notes on his. Judge, we have an offer of 12 from the state. We've been negotiating in good faith with the state prosecutor's office. We're seeing if we are close to a meeting of the minds and a resolution. And my respectful request is to reset for a docket call to see if we can get to a number that we can agree. My client's a nonviolent offender. Mr. Wilson's a nonviolent offender, right? This is a man who's just never been able to beat drug addiction. And we understand that there are consequences for that. We are not shying away from those consequences. One of these is a bail jumping. It's a misunderstanding that came out of do I have to go to court during COVID or not? But it's not like, he was on the run. He didn't flee and abscond and commit new offenses like some, like for example, a client who was here earlier today. So I'd ask the court for a reset for a docket call to see if Mr. Woodwike and I can come to some agreement that we can abide by.
State.
Judge, I'm unopposed. We have had numerous discussions regarding Mr. Wilson. If we could have one more docket call, I would note that on the bail jumping, that I believe this is our first docket call. If we could have one more and hopefully reach a resolution for Mr. Wilson, state would not be opposed to that.
All right, court, Mr. Wilson for a final docket call on June 14th.
Okay, 1:30, Judge.
1:30.
Yes, sir. Anyway, I'll be in touch. I'll put you on the video. All right. Thank you, sir. Thank you, Judge. May I be excused?
Just 1 second. So, yes, thank you, Mr. Ashmore.
Thank you, Judge.
Sis Keel, you're going to first.
All right, is this Ms. Keels?
Yes, it is, Your Honor.
All right, is this a plea today, Mr. Stevens?
Yes, sir.
Can you tell me what the terms are, sir?
Yes, Your Honor. She's charged with a state jail drug offense. It's being reduced under section 1244A. She'll be given 65 days in the county jail with 65 days credit. There will be a $2,000 fine. There is $290 in court cost. Excuse me. $180 in restitution. and $610 in reimbursement fees, Your Honor. Oh, and also, I'm sorry, go to 1245, a misdemeanor marijuana possession.
All right, Ms. Keels, if you'll raise your right hand. Sir, I'm sorry, ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, continue. Make sure you speak up loudly and clearly so I can hear you, and so my court reporter can take it down, okay?
Yes, sir.
All right, you are Heather Lynn Keels, is that right?
Yes, sir.
Ms. Keels, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by Mr. Bill Stevens as your attorney. Are you pleased with his representation?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Stevens, do you believe your client to be competent?
Yes, I do, Your Honor.
And you've explained to her her legal rights?
I have, Your Honor.
And you believe she understands them?
Yes, sir, she does.
All right, Ms. Keels, you heard Mr. Stevens tell me what the plea agreement was. Is that what you're asking the court to approve today?
Yes, sir, I am.
You understand that if the court approves this and you're let out of jail, you understand that you are going to be ordered to pay the fine, the court costs, the restitution, and the reimbursement fees. You understand that?
Yes, sir. Will I be able to pay it out?
We can put you on a payment plan, but if you miss a payment, you don't show up, then I'm just going to issue a warrant for your arrest and we're going to bring you back in here.
Yes, sir.
All right, Ms. Keels, you are charged by indictment with a possession of controlled substance of penalty group 1, less than 1 gram. A state jail felony carries a range of punishment of not less than 6 months or more than 2 years in prison. However, in this case, the agreement is to reduce that charge for punishment to that of a Class A misdemeanor. If the court approves this plea agreement, you would be convicted as a felon today, and you would be punished with a Class A misdemeanor level of punishment, which means your jail time could not exceed more than 365 days, and your fine could not exceed more than $4,000. Do you understand that?
Yes, sir.
Understanding all of that, do you still wish to go forward with your plea?
Yes, sir.
All right, Ms. Keels, how do you plead to that offense?
I'm guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Stevens, any objection to state's evidence?
No objection.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor. Just I'll advise the court that I have to explain to Ms. Keels what she needs to do after she's released about going to the courthouse and setting up a payment plan.
Ms. Keels, if you've got something to say, why don't you tell it to Mr. Stevens first? You raised your hand. You raised your hand. Why don't you mention to him what it is you wanted
I'm
to say?
still talking about my classes.
Oh, go ahead.
I've been doing the 12-step classes in the CASA and the opiate class. I just did the opiate class for an extra and stuff while I've been in Henderson County.
That's great. That's great. Self-improvement, self-education.
Yes, and preaching a lot.
That's great. Those are all good things. There are things that you need to keep on doing when you get out of this jail also.
Yes,
Okay.
sir. Thank you very much.
You're very welcome. Mr. Woodwhacker, Ms. Heisel, can someone give me the facts to support the plea?
Yes, Your Honor. On the date in question, Wills Point Police Department performs a traffic stop on Ms. Keel's vehicle for disregarding a stop sign and a tail light out. She pulls into a gas station and they notice signs of nervousness. Wills Point Police Department sees a marijuana cigarette on the dashboard and they notice constricted pupils on Ms. Keels. She admits to the marijuana and they search and find in the center console a glasses case with paraphernalia and 0.33 grams of methamphetamine.
Thank you, Mr. Woodwhacker. Any objection to that summary, Mr. Stevens? I'm sorry for the feedback. I don't know what the problem is.
No objection.
All right. Then, based on the evidence, the court will follow the plea agreement in this case. The court convicts Heather Lynn Keels of possession of a controlled substance in Penalty Group 1, less than 1 gram. Court punishes her under Section 1244A of the Texas Penal Code at 65 days in the Van Zandt County Jail. court will award her 65 days credit towards that sentence for time that she has been in jail on this cause. The court also orders her to pay a $2,000 fine, $290 court cost, $180 reimbursement. I'm sorry, $180 restitution, and $610 reimbursement. The court will also dismiss under Section 1245 a possession of marijuana less than 2 ounces. Ms. Keels, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go with Deputy McLeish to be fingerprinted. And as Mr. Stevens says, when you get out, if you get out before 5 p.m. today, come over to the courthouse, 3rd floor, ask for the court compliance officer, and set up a payment plan to discharge what you owe. If you don't get out before 5, then just be here by tomorrow sometime before 5, okay?
Yes, sir. Thank you.
All right. Thank you. Good luck to you.
Thank you. Sam, you'll come over here.
Yes.
Ms. Burns. Yes. Do you need to speak with her at all? I do not. Okay. Yes, sir.
Or Mannas,
That is his name.
did they fix that now?
I don't think so.
Okay.
Today was
So
not
just the hearing.
right.
Deputy, please.
Yes, Your Honor.
Do you want a speedy trial? I'll give you a speedy trial.
I know.
I've only got, let me check my drawer. I've only got 3 left. I'll give you one of them. Who do we have left?
We have Mr. Kyle Casey in the room.
All right, Mr. Casey, step on up. Got some questions for you. All right, Mr. Casey, I see here you're wanting me to give you a court-appointed attorney. You're saying that you're indigent. Got some questions about your form.
Okay.
You say that you don't rent, you don't own, you don't reside with family, but you're not homeless. Not all of those can be circled no. And then you say you've got rent, mortgage, and utilities. So either you're thoroughly confused or you've got me thoroughly confused, or maybe both.
The home I'm in right now, I'm buying from the County Commissioner Precinct 3, Terry Phillips, and I'm 6 months behind right now because of contract with my work, and they canceled the job that we were doing, and he's kind of worked with me, you know, and I have some people that's staying at my house right now that's helping me, you know, not get further than 6 months so I won't be thrown out of my house.
Now, who did you say? You said you're buying from the Commissioner of Precinct 3?
Terry Phillips, yes.
Vincent County?
No, Smith County. Smith County. Yes, sir.
So you are renting.
Rent to own. I have 6 months left on, or 3 months actually, and then it just goes to $200 a month for property or lot rent. Lot rent. I owe 2 months of 503, and then there'll be $200 a month for the following 4 months for lot rent, and then the house will be mine. But right now it's kind of up in the air.
So you have a job or you don't have a job?
I do have a job, yes, but right now the contract one of our contracts canceled, the biggest one we have, and we're just on a hold right now.
What do you do for a living?
I was a welder until the virus, and then I got laid off for 9 months, and then it just got hard after that. I started framing houses. Used to do that when I was younger, and remodeling, things like that.
Do you own vehicles?
I have some older vehicles that don't run. I don't have my driver's license because of that DWI I'd gotten before, and I have some older vehicles that don't run.
So you don't have any assets that you could sell to hire an attorney?
Not at this time, no. And behind on my child support, so when I'm not working, I can't really support my kids. My ex-wife, she's been helping me out as much as she could. She took me up to probation yesterday, and I'm just grateful for her, and all the help she's helped me out with,
Okay. All right, let me keep on looking at your form and go ahead and have a seat. I'll call you back up just a second.
Thanks, sir.
Deputy McLeish, is that all we have left today? Other
Well,
than-
Your Honor, I dropped the ball. Mr. Jones has got extradition paperwork that I guess should have been addressed when he was in front of you on the other docket, but he is back. We do have the paperwork.
Okay, give me just a second and I'll deal with him.
Okay.